So in this short video, we're going to be taking a closer look at the Barton and Armstrong case, which is a duress to the person case. All right, so in this case, Barton was general manager of a company which Armstrong was chairman of the board of directors. The complex array of shareholdings in the principal company and its related entities revolved chiefly around a surface paradise development in which both men had significant interests, and their relationship broke down and negotiations took place with the aid of intermediaries for the purchase of Armstrong's interest. Barton alleged that he signed under duress a deed on terms sought by Armstrong after a series of provocations against him and his family, including death threats. So this relationship had obviously broken down significantly. Armstrong denied the allegations and claimed that Barton executed the deed because he had concluded the deed to be favourable. And there's actually some evidence to suggest that the contract was on quite favourable terms. Justice Street in the Supreme Court of New South Wales found, as a matter of fact, that death threats had been made against Barton and that he had taken them seriously. But at trial, he also held that the threats did not actually coerce Barton into executing the deed. So there were other commercial reasons why he'd entered into the contract. And then a majority of the Court of Appeal dismissed Barton's appeal on the grounds that he'd failed to establish that he would not have executed the deed, but for, being very important there, the but-for test coming out, but for Armstrong's threats. Okay, and then Barton then appealed to the Privy Council. We'll come back to that, but for the relevance of that in the case reading questions that we go through. So the issue before the Privy Council was whether a party who'd entered into a contract under duress would lose the right to rescind if it was established that they'd also had separate reasons for entering into the agreement. Okay. And here, remembering that it suggested that Barton had quite substantial and good commercial reasons why he might have entered into that contract. In terms of what was held in the case, a majority of the Privy Council found against Armstrong. They said that Barton could have executed the deeds on the ground that they were in his interest, even if Armstrong had made no threats and exerted no unlawful pressure to do so. However, because the threats and unlawful pressure did in this case, in fact, contribute to being a very different test to that but-for test mentioned earlier, because the pressure did contribute to his decision to execute them, the deeds were held to be as a result of duress. So we'll go through the case reading guide questions in turn. All right, so the first question that we had was, what contract was Barton seeking to have set aside on the ground that he'd been coerced into signing it? And it was a contract for the transfer of Armstrong's shares. Okay. The second question, in terms of that contract, the contract for the transfer of Armstrong shares to Barton, and it was for $180,000 over 3 years, and Barton was the guarantor. Okay. So why did the trial judge conclude that Barton had not shown that he'd acted under duress? Well, it's interesting because the trial judge did recognise that the threats were real and that they had been actually made. But the trial judge Justice Street felt that the threats had not coerced Barton into signing the agreement. And Justice Street said the agreement went through for the predominant reason that Barton was convinced it was indispensable to the future of his company, and he had to get rid of Armstrong if the company was to survive. So sheer commercial necessity was seen to be the real and even possibly the sole motivating factor for signing the contract. All right. Now, in terms of the third question then, so what did the majority say was the test for determining whether a contract should be set aside where illegitimate pressure was applied by one party to the other? So here at the trial and Court of Appeal level, they'd interpreted the test to be that but-for test. So but for the pressure Barton wouldn't have signed. However, here the Privy Council stated a very different iteration of the test. They said that it was only if Armstrong's threats were a reason, as opposed to the sole or the dominant or the only reason for entering into the contract, Barton would be entitled to relief. So according to this test, it's irrelevant whether Barton might have entered into the contract with Armstrong if there hadn't been threats. That's irrelevant. Here, if the threats were one of the reasons, a reason why he entered, then that would be seen to be sufficient to make out duress. According to the majority, if Barton had had to establish that but for the threats he would not have entered the contract, would he have succeeded? No. Okay, and then the next part of the question is why then, according to the majority, did he succeed? Because no such onus actually lay on him. And at 633, page 633 of the judgment, it stated that it was actually the contrary. It was for Armstrong to establish that the threats which he was making, in fact, contributed nothing to Barton's decision to sign, and he was unable to show that. Okay, so having a look at the fifth question then. Did the dissentients disagree with the legal principles stated by the majority? And that's the principle around the threats being a reason for entering into the agreement as opposed to the sole or only reason. Well, no, the dissentients didn't agree with the actual test that was stated, so they agreed with that test. So on what grounds then did they disagree with the majority? They said that a man in a state of fear may yet act voluntarily, i.e. totally for other reasons or motives. Okay. Now, at 636, you can see that part of the dissent. So they clearly interpreted Barton's motivations differently. So they said, despite the threats, the reason why he entered was the commercial necessity. So here they didn't even see the threats as a reason for entering. So they just interpreted the facts differently. And that's consistent with, well, not consistent with the test applied by Justice Street, but it is consistent with Justice Street's reading of the facts here. So Justice Street found that Barton was motivated to enter into an agreement by sheer commercial necessity. So it wasn't even a reason for entering into the contract. In terms of question 6 then, what observation is made by the dissentients about the realities of commercial life and their effect on consent and voluntariness in contracting? Okay, so if you read the dissent closely, you can see that they're making comments on the lines of, you know, many acts are done under pressure, sometimes even overwhelming pressure, and that one can say that the actor had no choice but to act in many circumstances just in normal business affairs. So absence of choice doesn't necessarily negate consent in law. And for this, the pressure must be of such a kind which the law does not regard as legitimate. Okay. In terms of the next part of the question, are you comfortable with the test proposed in this case for determining whether a person was coerced into entering the contract? Once illegitimate pressure is established, the onus is on the party who's exerted that pressure to establish that it did not contribute in any way to the decision to enter the contract. And given that, you know, this case involved death threats, I don't really have a problem with that, because if you behave properly, you're not going to end up in that type of situation. Now, in terms of the last part of that question, it was how can a person claim to have been coerced into doing something the evidence suggests they would have done anyway? You know, that just really comes down to the fact that it's important to protect the notion of voluntary consent. Okay. Finally, number 7 then, it's quite a long series of questions. So it says the test proposed by this case seems morally acceptable when what is at issue is the use of plainly immoral and illegal conduct. So that comes back to that point I was mentioning before. I mean, this involves death threats. It's not really, it's pretty straightforwardly bad behaviour. such as threatening a person's life. Suppose that the circumstances are that one party has exploited the other's relative economic weakness. Is coercion of the will really the point here, or is it the use of illegitimate pressure in contract negotiations? Well, you'll see when we get to the economic duress cases that it's harder to establish economic duress than it is duress to goods or to the person, because there's, I guess, that scope for, just normal bargaining to be quite hard bargaining. But in terms of this particular case, I mean, the focus really is on the illegitimacy of the pressure. Yeah, so the illegitimate pressure would have the effect of coercing a reasonable person to sign. So that's like quite an objective view of contract, rather than subjectively looking at what may or may not have individually coerced the will of a particular person. So, okay. And that concludes Barton and Armstrong. Thanks, guys.